Rodeo Drive, exterior, day. Vivian goes shopping on Rodeo Drive, Los Angeles. She's dressed in hot pants and a crop top. Vivian looks at the pedestrians, so different from the ones she's used to seeing on Hollywood Boulevard. Boutique, interior, day. A very expensive boutique. Through the window, we see Vivian walking through the entrance of the shop. Close shot on a saleswoman who is arranging some flowers in a big vase. She is very neatly dressed and looks a bit snobbish. May I help you? I'm just checking things out. Are you looking for something in particular? No. Well, yeah, something conservative. Yes. You got nice stuff. Thank you. How much is this? I don't think it would fit you. Well, I didn't ask if it would fit. I asked how much it was. How much is this, Marie? It's very expensive. It's very expensive. Look, I got money to spend in here. I don't think we have anything for you. You're obviously in the wrong place. Please leave. The next day, Rodeo Drive, exterior day. Vivian appears on the screen. She's wearing a very elegant white suit, long white gloves, and a black hat. We notice she's carrying several bags full of clothes. Boutique, interior day. We're back inside the boutique from which Vivian was rudely ejected the day before by some snobbish saleswoman. Vivian enters the boutique. Hello. Do you remember me? No, I'm sorry. I was in here yesterday. You wouldn't wait on me? Oh. You work on commission, right? Yes. Big mistake. Big. Huge. That, of course, was Julia Roberts in the film Pretty Woman. In the first scene, because of how she was dressed, the sales assistants are making conscious assumptions about Vivian's ability to pay for the clothes, and accordingly refuse to serve her. Vivian doesn't intend to negatively influence the sales assistants in this way, and she certainly doesn't intend to positively mislead them. But the point is that her conduct, the way she's dressed, causes them to make assumptions. In this case, conscious assumptions. But what if we change the facts? Picture the scene. A fancy restaurant. I'm not going to do the voices this time. A fancy restaurant, middle-aged customer. We'll call him Viv. Sits down. Well-dressed, expensive-looking. Wants to be served, dine well, and then he intends to do a run-up. He places his order with the waiter. We'll pause the film. What is he hoping or intending will happen? He's hoping that the waiter will not question him, will not ask him to prove his intention to pay. The best case scenario for Viv is that it doesn't even cross the waiter's mind that Viv doesn't intend to pay. And so Viv is hoping that because of the way he's behaved, the waiter will just assume, without thinking, that Viv can and intends to pay, and so he'll bring out the food. But if while the film's paused, he walked into the scene and asked the waiter what his contemporaneous awareness was of what was being said to him, he'd say, well, the customer ordered 6 oysters, steak rossini, and the chocolate souffle. But is the waiter nevertheless influenced, perhaps subconsciously, perhaps influenced into making an assumption by what the customer has done? Well, you could test that by changing the facts again. If a 7-year-old boy had come in and sat down at the table and placed that order, would the waiter have served him? Or would it have been more like Vivian on Rodeo Drive? It is these questions, the idea of unconscious influence, that lie at the heart of this evening's talk. I'm Simon Oakes. I specialise in commercial disputes, commercial fraud, banking and financial services, and I spent probably too many years arguing about misrepresentation and reliance in the context of LIBOR and other market manipulation cases that followed the great financial crisis. With me tonight is Toby Chandler, who's an expert in commercial disputes, insurance, profneg, and international arbitration. He's recognised by the Legal 500 as a rising star who's highly analytical and commercially sound. So what are we talking about tonight? Deceit claims. This is the tort of deceit. We'll be pretty familiar with it. First, there must be a representation of fact or law made by words or by conduct. And often there's very little distinction between a representation and a non-disclosure, but we'll come on to that. It must be false. The representation must be made with the knowledge that it is false, willfully false, or at least made in the absence of any genuine belief in its truth, recklessness. Fourth, it must be made with the intention that it should be acted upon by the claimant or by a class of persons that will include the claimant. And fifth, and importantly for tonight, it must be proved that the claimant has relied upon the false statement and has sustained damage by doing so. And one of the important things to keep in mind tonight is that reliance really is causation. There must be a causal link between the representor's statement and the representee's decision to enter into, in this case, a contract. They must have relied on the statement at the moment of contracting. In a fraudulent misrep case, it need not be shown that the statement was the sole cause of the contracting, or even the main cause of the representee's decision to do so. It's enough if it is a cause. In negligent and innocent misrep cases, you probably do need but-for causation, but we're talking about deceit, so it needs to be a cause. Representations. Well, starting at the top, most obviously, an express representation. What a reasonable person would have understood from the words used in the context in which they were used, because here express means words. But deceit can also be perpetrated by non-verbal conduct. And as I'll come on to explain, I kind of have a problem with calling this an implied representation, but that's what we say it is. And so you've had the first example already from the famous case of DPP and Ray. The person sitting down in a restaurant and ordering a meal makes a representation by doing so. Or the person hailing a taxi represents that they have the means and intention to pay for it. And as Toby will explain later in Spice Girls and Aprilia, the approval of promotional material by the Spice Girls was held to be a representation that they didn't know that anybody intended to leave the band. And so when you're trying to construe an implied representation, you look at what a reasonable person would have inferred was being implicitly represented by the words and conduct in their context. I've set out on the screen the helpful test from Geest and Fyfies, which is, I think, actually quite difficult to follow. But it says, whether a reasonable representee would naturally have assumed that the true state of fact did not exist. So in our waiter example, does the waiter assume that the customer has money? And that had it existed, i.e., if the customer in fact has no money, the waiter would in all the circumstances necessarily have been informed of it. That's a good way of testing what the representation was. And usually, silence is not a representation. But again, query, what is silence? A person who takes active steps to conceal a defect, don't use any words, that can constitute a representation. And that's the case of Gordon and Selico, where somebody deliberately covers up dry rot by painting over it. The dividing line between a positive representation and a non-disclosure is porous. When the mere offering of a contract can constitute a representation that is very close to a non-disclosure. And so there is a significant undermining, potentially, of the doctrine of caveat emptor. Reliance is where we're driving towards this evening. And the key question in a series of first instance authorities since about 2010 has been, is it a legal requirement for a claim in deceit that the claimant was aware of the representation on which the claim is based? And this idea comes from the 19th century of Edgington and Fitzmaurice, a misleading prospectus case, where the company directors issued a prospectus saying that the money they were raising would go into expanding their abilities to supply fish, and in fact was to pay off the liabilities of the company, which is going bust. But in modern times, the problem starts in Riferson with Mr. Justice Christopher Clark, as he then was. And what he said was that a claimant has to show that it understood the representations that were being made, and he has to show that he understood the statement in the sense which the court ascribes to it, and that having that understanding, having that specific understanding, he relied on it. He says that may be particularly significant in the case of implied representation, which of course it was. And this really took off in the banking manipulation cases, of which it was considered most detailed in these three: Marmay, Leeds, and Loreley, two of which are just judgments of Mr. Justice Cockerell, as she was. Marmay was a Yorubal case, where Mr. Justice Picken said that he thought, obiter, that claimants needed to have given some contemporaneous, conscious thought to the fact that representations were being impliedly made. Otherwise, the requirement for reliance is being watered down. Now, that obviously does not accommodate the waiter example, because as I illustrated at the beginning, the waiter does not contemporaneously consider that a representation is being made to him that the customer intends to pay. So that just doesn't work, that test that Mr. Justice Picken threw out there. But it was picked up and run with by Mrs. Justice Cockerell in Leeds and Barclays. And she said that there's a requirement that the representation is actively present to the claimant's mind. That's the wording from the 19th century case of Edgington and Fitzmaurice. And she expressly contrasts that to an assumption. She says it's not enough if a claimant makes an assumption. And she tries to shoehorn the waiter example in by saying, well, that's a quasi-automatic understanding. But it's not exactly an assumption. And then she doubles down on that in Loreley financing. That's a collateralized debt obligation case, where she said that the claimant must be aware of the representation, must have it actively present to their mind when they act on it, and that assumptions, by contrast, are the territory of non-disclosure. And so all of those authorities were used by the defendant banks to argue successfully that if a claimant hadn't contemporaneously, consciously considered the misrepresentation that was being made to them, and they very rarely could, because an implied representation necessarily doesn't have a definite form of words, then they can't have relied. Not that they didn't, in fact, but they could not have relied if they didn't have that consciously in their mind. It's a problem for the waiter, right? And there are a few reasons for that, and Toby's going to expand on them in more detail. But the big reason that Mrs. Justice Cockerell had as to why awareness is necessary is that she says it is required logically for there to be reliance. She says a misrepresentation cannot, as a matter of logic, cause a claimant to act unless it has an impact on their mind. And it can't, how do you have an impact unless a claimant is consciously aware of it? She says it's the causal link or the logical bridge between the representation and the reliance. And that unless you have some aspect of conscious awareness of what's being said to you, you cannot have relied on what's being said to you, whether it be in words, conduct, or by somebody's clothes. But what didn't really get examined, and what Toby's going to talk about, is, well, why were those assumptions made? Why in those cases does somebody assume that LIBOR isn't being manipulated? Why does a waiter assume that the customer can pay? What is it that causes that, and who's to blame? The second main reason is to maintain distinctions with non-disclosure. And I get that you shouldn't have misrepresentation eliding with non-disclosure, but to my mind at the time and still now, the way you deal with that is to police a case at the front end and to be very clear about what constitutes a representation and not to use the release valve of reliance at the back end. And in practice, to resolve ambiguity, to make sure that if you've got two statements which are kind of similar, but one of which you've got a statement which has two meanings, one of which is false and one of which is true, you want to make sure that the claimant has relied on the false one. And the problem in all of this, when you're coming to reliance, is it's very difficult for a court to look into the processes of a claimant's brain. And this awareness test is so difficult for a normal person to satisfy in an implied representation case, and particularly one where the representation isn't as obvious as when somebody sits down at the table, when you've got complicated financial products, for example. And the awareness test, as I've hopefully illustrated, just really struggles with examples which we think should work, like the waiter. That most of the time, a claimant is aware of the conduct which gives rise to representation. The waiter is aware that the customer sat down at the table and he's smartly dressed. But the waiter just won't always have been consciously aware of a representation that the customer intends to pay. And sometimes the claimant isn't even aware of the conduct which gives rise to the representation. Yeah, in the waiter example, you can see the customer sitting down at the table. But in the dry rot case, you can't even see, you don't even notice that the rot's been painted over. And that's the whole point. That's the whole point of the trick, that you don't notice that someone's painted over it. So if someone says to you, You didn't notice the representation. You didn't consciously think of it. Therefore, you can't rely. So, but that's what the fraudster wants. That's the whole point of the trick. And if you go back to that Geeston-Fyfies test and ask those people, well, why did you buy the house with dry rot? Why did you serve an impecunious customer? Why did you contract with a band about to break up? They'd say, well, I'm not an idiot. I assumed that the house didn't have dry rot. I assumed that the customer had money. I assumed that the band was going to stay together. The interesting question, the one that didn't get asked, is, yeah, what caused that assumption? That's what Toby's going to talk about in a sec. And so many implied representation claims founded on that rock or were settled for about 15 years because the claimant in those cases couldn't say that they'd given the conscious consideration to the implied representation. That's to say nothing of representations made to computers. And so on that note, I'm going to hand over to Toby to tell you about what the Privy Council decided in this case.
Thank you, Simon. I'm afraid my section doesn't start with any more from Pretty Women, but if you stick around at the drinks, I'm sure we can rustle up a few more scenes. It's worth just starting with a cast list for Credit Suisse. The judgment opens by describing Ivanishvili as the former Prime Minister of Georgia and a very wealthy businessman. That might be underselling it somewhat. Wikipedia reports that he is the richest man in Georgia, with his wealth estimated at 7.6 billion, a figure equivalent to nearly a quarter of Georgia's GDP. On the other side of the equation sits Credit Suisse and its trader. Mr. Lescodron's fraud was very widely publicized and had all sorts of international ramifications for Credit Suisse. He was ultimately convicted in Switzerland of fraud and later committed suicide under house on early release. In the face of this, Credit Suisse ran what the Privy Council described as a flat earth defense. It's worth noting that there was no admission of really anything from Credit Suisse. This was really up is down, black is white sort of stuff. And most fundamentally, there was no admission of the fraud at all, notwithstanding that he had admitted it himself and indeed been convicted. It perhaps will come as no surprise that at first instance, Credit Suisse lost on absolutely everything. There were appeals up to both the Court of Appeal and then up to the Privy Council as of right on the contractual and fiduciary duties claims as well. Those were also subject to some modest adjustments, also unsuccessful. But the real meat of this decision, and the interesting part, is the answer to this question about the requirement for conscious awareness. And the context for this was that this had been successful in the Court of Appeal. Credit Suisse had beaten the misrepresentation claim. And that might have something to do with the fact that Christopher Clark was on the panel hearing in the Court of Appeal. So what was the issue? There was no appeal on whether there was a representation. It was accepted that implicit in the bank agreeing to manage funds, there is a representation that it won't do so fraudulently. But there was no plea and no evidence that it was ever understood that this implied representation was being made. It is exactly the kind of assumption case that we're dealing with. Is it necessary for Ivanishvili to say, I knew, as we were discussing this opportunity, that they were telling me that they wouldn't manage the assets fraudulently? Who can give that evidence? Who can really, is that the requirement that the law imposes, that you be able to say that in order to succeed in your deceit claim? I think what is particularly helpful about this decision and why it is important for us as litigators to understand is that it is really grasp the nettle kind of stuff. The Privy Council says this very clearly, that we have to call a spade a spade. It won't do to try and split the baby and say that there is a process of awareness or understanding distinct from the assumption, or that there is knowledge and awareness that operates in a split second. You have to call it what it is, which is that it looks like an assumption because it is an assumption. And the question is that right or is that wrong? We've touched briefly on these cases already, but it's worth just having them in mind because they weigh pretty heavily for the Privy Council. The first is the Gordon and Selco one. So if I sell you my house and I paint over the dry rot, there's no conscious awareness of the issues, and that's exactly what I'm trying to achieve. You don't know that there is dry rot. And the second example, and one that is factually the most important, is the Spice Girls and Aprilla case. The Spice Girls knew that Jerry Halliwell was going to leave the band, and yet nevertheless agreed to participate in a marketing deal for Aprilla. By entering into that deal, do they make a representation that no one is about to leave the band? And Court of Appeal says yes. Now, what the Privy Council says is this is really an operation of the same underlying idea as the dry rot, as the waiter. The sponsor cannot know. It wouldn't have crossed their mind, because indeed it's so unthinkable that Jerry Halliwell would ever leave the Spice Girls. There isn't some split-second moment where the sponsors worry about the security of their favourite girl group. No, it's an assumption. So there's a choice. Either Raiffeisen and the cases that follow it are right or they are wrong. You have to decide. You can't have it both ways. And the board is clear that the contemporaneous awareness and understanding of the representation are not an essential element of the deceit claim. And what we just want to do now is just unpack what it is that sits behind that. And the board says that at its core, there are three fundamental misconceptions that have led to this outcome. Now, the first is reliance and awareness. The idea is pretty simple. Unless you are aware that a representation has been made, how on earth can you say that you have relied upon it? And put in a sentence, it's easy to agree with that. It's easy to see how you follow that route. But what the Privy Council is saying is that is the wrong way to break down reliance. The way to break it down is twofold, and they use these terms. The first is to say, well, is there reliance in belief? So has the representation caused the claimant to hold a false belief? And the second requirement is reliance in action. Has the claimant acted on that belief and so suffered a loss as a result? Those things don't necessarily require you to have an awareness of the fraud at the time, and don't justify the imposition of an additional requirement. Now, there's an example to just unpack that a little bit, and it's the cab drivers. And let's call them, as the Privy Council does, Watson and Holmes. Now, poor old Watson, he, seeing the man on the side of the road put his arm up, blithely pulls in and takes the fare, not appreciating that the man has no intention of paying. It is only Holmes who sees it in an instant, that he sees that the man, by putting his hand up, means to call the cab, means that he has money in his pocket, and means to give it to Holmes. What the Privy Council tells us is it can't be right that only Holmes can recover and Dr. Watson is left without a remedy. That, you might say, is elementary. It's very generous of you all. Second misconception, ambiguous representations. So, this is an idea from Smith and Chadwick. If a statement genuinely has two meanings, in an action alleging deceit, you have to show that you understood the statement in order to show reliance. Now, what the Privy Council says is that mistakes what will ordinarily be necessary evidentially with what is in fact a legal requirement. What you need to show is not that there's a conscious awareness of what the court decides is the appropriate construction of a representation, but whether the claimant understood it in the fraudulent sense that the defendant intended it to be understood. Again, there's no additional requirement, albeit you can see that it's very often that you will find that there's this conscious awareness, but because it is so often there, it is mistaken as something that has to be there. Now, finally, representations and assumptions. It's the third misconception. And here we may be into stormier waters. The challenge laid is if the claimant has acted on an assumption and not on the actual representation, how can it be the representation has caused the false belief? The fault lies with the claimant and with their assumption. The Privy Council says not so, and it's worth taking a moment to pause on this 175 paragraph, because it's not a particularly easy one to unpack, I don't think. Now, the first point that's being made here is that representations and assumptions are not mutually exclusive. Fine. The second point is you can say, well, you can act on both an assumption and in reliance on a representation. Right? That's fine as far as it goes. It's a little self-proving. There must be some inferential point where something stops being referable back to the representation. But equally, the point at a very high level abstraction that the Privy Council is making, and I think the way this ought to be understood, is that you have to say, well, that assumption has come from somewhere. Just because you are acting because of an assumption, that doesn't mean that there aren't echoes and reverberations from the representation that has been made. So, if we take the example of the diner who orders food, there's both assumption and reliance. There's reliance because there's reliance and belief because the diner's there is reliance belief because the belief that is caused by the diner sitting down to pay, and that reliance crystallizes by serving them. So we're not dealing with this distinction, the Privy Council says, between an assumption and reliance. What we're looking for is there reliance and belief? Does the statement cause you to act the way you did? Now, I think that's fine in the diner's example, and it's fine where the situation is so clear cut. But we already knew the answer to the diner's question. We already had House of Lords authority on that. I think what this passage perhaps doesn't help us with, and I think where we will continue to see the fault lines on this point, is what happens with this notion of reliance and belief on a more complex factual pattern. Reliance and belief must at some point have some kind of limiting factor. You have to be able to articulate when you're presenting your cases on these kind of points, why it is the representation has caused a claimant to hold a particular view. It isn't a charter just to say, well, I assumed something out of nothing, and therefore I have a claim. You do have to be able to trace where this representation has come from into the belief, into the action. Now, there's just one final difficult passage that I think is worth dwelling on again. Now, this is this line between misrepresentation and non-disclosure. And it's something of a postscriptum judgment. Like I say, it's not the issue the Privy Council are dealing with directly. It's something they have to weigh in setting the parameters of the policy of the tort of deceit. It's a question about really where a representation comes from. And I think all we can really take from this passage, if we take anything, is a statement of the problem that is left on this, rather than an answer to it. So the issue, they say, is, on the one hand, you have cases where something that a defendant has done has caused a false belief, and you have other cases, which are not non-disclosure cases, where you have failed to inform the claimant of something. So in some examples, that's easy to point to. In Gordon and Selco, when you paint over the wall, you take an action that causes a belief. When you sit down at the restaurant, you cause the belief. When you hail the cab, but that doesn't go. That doesn't mean that any silence in the face of issues is a misrepresentation. It doesn't always follow, and I think there's a express acknowledgement that this is a hard line to draw. How does it work for the Spice Girls? Is it enough? And we have that it is, at least on the facts of the Spice Girls Aprilla case. Is it enough to say that in entering into the marketing contract, you represent that the band's going to stay together? But how far does that notion go? How do we square it with our deeply held notions as contract lawyers that it's the buyer who must beware in entering into contracts? It's for them to make their inquiries. There must be some line. Now, I think Simon is right when he says that, well, if we have a greater clarity, and if we have rectified our concern that reliance has become unduly difficult to show, it may well be that this is the battleground on these kind of cases, is identifying whether there is sufficient action to say that something has been done to cause the claimant to hold a false belief, or whether it falls into the second category of a failure to inform. So it's a difficult passage, but I think it is one that, we will have to return to. So, what now? I think that there is a degree to which you have to see that on the facts of the case itself, and even as a general proposition, this is the only practical outcome. It must be that any other result is a fraudster's charter. It amounts to saying that the more successful, the more sophisticated a fraud, the less likely it is that you have a deceit claim. If you manage to pass completely under the radar, then it is impossible for a claimant to prove reliance. It just cannot be right. So it is a welcome change, and it's welcome not simply in result, but also, I think, in clarity and stability for the law. I think that doing away with the difficult notions of split-second reliance and the quasi-automatic reliance they've always been difficult notions to unpick. But here we have an answer from the Privy Council, which is that you call a spade, but that doesn't necessarily mean that you can't establish reliance. Now, what we're going to do with just the next part of this talk is just talk you through a few ideas about where we think this might have some ramifications. I'm just going to touch on this notion of sort of a fraud on the market and some of the sort of recent scandals, and then I'll hand over to Simon on tech and a run through of FSMA claims. Now, we ought to pause on Crosley and Volkswagen, because Mr. Justice Waxman ought to be congratulated for having bucked the trend. Now, Crosley and Volkswagen is a decision arising out of the Dieselgate scandal, and for the uninitiated, the issue in the Dieselgate litigation and the issue in Crosley is that VW are alleged to have fitted their cars with what's called a defeat device, so that when it's being tested for compliance with the emissions regulations, it will pass them, but in all other times, it will run in mode 2 and emit a far greater amount, so cars are not in fact road legal. So a great number of claimants bring a class action against them. Now, the reason it's worth dwelling on this decision is because Crosley was a strikeout application in respect of precisely this point. Volkswagen say, well, how can you, buyer of car, have a claim in deceit when you weren't aware of it? Did you apply your mind to the question of whether the car you were buying was roadworthy when you paid for it? Probably not. Now, as I say, Waxman deserves some plaudits. He refused to strike out the claim, and it remained live. But I think it's telling that what we get after the Privy Council is that this is not just not strikeable, it must be right, or at least right on the sort of assumed facts. So I think it is a real change in the dynamics of the recent first instance decisions, and it is a vindication of what's said, what's being said there. And I think, in fact, you can probably go further than what's being said in Crosley, that it's a developing area of law. It's been the contrary authorities have really been soundly rejected. Now, Dieselgate is a good example of where these kind of things arise. But what's sort of interesting about, one of the many things that's interesting about this decision is that it's kind of built for a scandal. It is exactly the kind of thing that arises as an issue because there has been some sophisticated fraud, because there has been a vast attempt to gloss over and obscure the truth from people. So I do think that it is a positive decision in that regard, and it is something that it is a welcome development in the law. I think that the note of caution that is to be sounded in these kind of sophisticated frauds, these frauds on the market kind of cases, is that you are still going to have to find the representation. You are going to have to identify where it has come from. It's not enough just to point to the silence. You are going to have to find the action that causes that notion of reliance in belief, in the language of the judgment. And so I think that it's not going to be the last word on this, but it's certainly a heartening decision, and it's one that brings, I think, a degree of welcome clarity to this issue. I'm going to hand you back over to Simon to talk about a few other areas, but thank you all very much.
Thanks, Toby. So, yes, exactly as Toby says, this was for so long used as a shortcut. If you've got you've got no awareness because your implied representation was just a lawyer's construct, so the claim gets struck out, as so many did, or as so many threatened to be. And so now fewer claims will be struck out. So there will either be more settlements or more scandals being raked over in public, which are good news for the lawyers. I always used to think that us claimant lawyers should be taken to a special claimant's dinner by the banks for spending so long and generating so much work with ingenious legal arguments. I'm still waiting for my invitation. Before we come on to Section 90A of FSMA, I just want to tidy up a point about representations to computers that I mentioned earlier, because the Privy Council say two things in paragraph 166 of Credit Suisse. They say that the bit that they're interested in is the part that says there's no reason in principle why in such a case, somebody filling in a form on a computer, there's no reason in principle why in such a case that person should not be held liable in deceit, even though the claimant is unaware of the making of the representation. That's the bit that they're interested in, is when somebody types into a form provided by an insurer a misleading statement, well, the insurer can't be aware of the representation because it's made to a computer. Then they say at the back end, the requirement to prove reliance can be met by showing that the claimant assumed and acted on the assumption that the information received by the computer was true when it was not. And I think to understand what they mean there, one needs to just go to this SCAT decision, which they cite earlier in the judgment, where it is said there by Mr. Justice Baker, Obiter, that the system design can be seen as anticipatory reliance on representations that will be made. And so what I think is going on jurisprudentially here is when you set up your system and you have a series of logic gates that you have to go through, and you program your system to say, if this answer is given to you, then process it in Y way. What you are effectively doing as the person, whether that's an individual or a company, is you are saying to the program, I will rely on an answer X in this particular way, and I authorize you to act automatically in this way as my agent. So it is reliance. It is conscious reliance. It just happens in advance. The reliance is done before the statement's been made, assuming that a statement is going to come in a particular form that slots into that space. So that's what's going on there. Section 90A FSMA. As you know, a Section 90A FSMA claim, over Section 10A, Schedule 10A, Section 90A, is a statutory cause of action that lets investors sue an issuer of securities, typically a listed company, for losses that are caused by misleading public statements or dishonest omissions, interesting point there, which we'll come back to, in the company's published information relating to the securities, and that where a claimant has acquired, continued to hold, or disposed of the relevant securities in reasonable reliance on the published information in question, then they can claim. And you contrast that with Section 90 FSMA, the so-called fraud on the market provision, which provides a remedy for investors who've suffered loss as a result of an untrue or misleading statement or omission, but where there is no reliance requirement in the statute. And the background to this is that Section 90A is introduced to comply with the UK's obligations under the Transparency Directive, which include enhanced investor protection and increased market efficiency. And the main ingredients of a Section 90A FSMA claim are a representation, a misleading statement or a dishonest omission in published information, annual reports, public announcements, market disclosures, things like that. No express need for an intention by the company, defendant, that the claimant would rely, although I sort of think it's just baked into the published information that you must anticipate and intend that people are going to rely, but statute doesn't say that. Reliance, that's the big interest, and that's why we're talking about it today, that the claimant has acquired, continued to hold, or dispose of the securities in reasonable reliance on the published information in question, and has suffered loss as a result. And so here are the words of the statute, which are too small for everybody, apart from those in the front row, to read. But I've highlighted the two most important bits, which are those parts that I emphasised a second ago. That they have to, the person who is bringing the claim, the claimant, has to act in reliance on published information, and to do so in circumstances and at a time when it was reasonable to do so. So this reliance question, reliance on the published information, is front and centre of a Section 90A case. And we could talk about this for ages. It's really a discrete topic, so I'm just going to take it as quickly as I can. Two key cases from the last couple of years. The Allianz and Barclays case about Barclays' dark pool trading system and alleged misreps about how that worked, and the Standard Chartered case about misleading statements for alleged failures to comply with US sanctions. First one's a judgment of Mr. Justice Leach, really quite long. Second one, a judgment of Mr. Justice Green, nice and short. There are three key scenarios in these cases. Scenario A, the most straightforward. The claimant reads the information and is influenced. Easy, direct reliance. Category B, the claimant does not read, but their representative, or the person who is directing or influencing their decision, kind of agent type figure, but not necessarily an agent, they're influenced, and they in turn influence the claimant. And this is, again, a notion that is known to the common law, the indirect. The easiest example is where you have indirect reliance on the gist of a representation. That's a concept that's been known to the common law for a long time. And relatedly, so where you've got the gist, the representation starts, the gist of it gets relayed, it reaches the representee and they act upon it. Pretty straightforward. More complicated and not really considered very much in the authorities. You've got it in Brown and Innovator 1 a bit, got it in Ross River, interestingly judgments of respectively Hamblin and Briggs. So if this does count for the Supreme Court, you can expect some interesting things in it. Where the misrepresentation comes to the advisor is misled by it, and the advisor doesn't pass on the gist of it, they make a recommendation, and the representee acts on that. So those are the common law analogues that exist for that scenario. And then you've got scenario C, and this is where the fight is. Neither the claimant nor their representative read what is in the published information. They don't read the statements, they don't see that there's an omission. But the claimants say that they're influenced because the market has read. Analysts in the market have read, and they have been influenced, and they have dictated the share price. And the claimant is influenced by the share price. And some call this scenario C, some call it common reliance, and of course the banks call it no reliance. And scenario C is the most hotly contested, and that's what I'm going to talk about. And the background to this is that basically category C investors tend to be index trackers, and they don't get protection under Section 90A if the investors are required to have read the published material, because they don't do that. They just track, they try and replicate the index or a particular series, a particular sector. And passive investors of this kind account for a massive share of the investing market, so it's a big deal. And in Barclays, Mr. Justice Leach just struck these claims out, the category C claims out. And what he said was that Parliament must have intended this reliance component, the difference between Section 90 and Section 90A, to have some content. He thinks it must be, Section 90A must be more than this mere fraud on the market in Section 90 of just, you put misleading information onto the market and I say that I suffered loss. He says that they must have intended, Parliament must have intended the common law deceit test for inducement and reliance to apply. And there's a wrinkle on omissions, which I'll come back to in a sec. He says that for an express representation, the law of deceit requires the claimant to prove that they read or heard the representation and understood it in the sense alleged to be false. You can begin to see why the Credit Suisse decision is kind of interesting for that finding. And he says, paragraphs 129 to 30, that reliance in this context requires 1, the application of minds, 2, to the published information, whether directly in scenario A or via those directing or influencing the investment in scenario B. So he found those to be arguable. He says those things don't exist in category C. You don't have the application of minds to the published information. Now, I said there was a wrinkle in relation to omissions because the deceit, Mr. Justice Leach says that the deceit test applies from common law to inducement or reliance, but there isn't this concept of a fraudulent omission in common law unless it's a misleading omission. You can't, there isn't such a thing as a representation that is just a dishonest omission. It doesn't exist. So what do you do with that? How do you fit that in? And what Mr. Justice Leach says is, well, a party just has to prove that it read the published information and that it acted in reliance on what it had read. And so you can see that this is very beguilingly attractive, in the most part, what Mr. Justice Leach says, to say, well, you have to have, when the statute says reliance on the published information, you therefore have to have read it. But in the Standard Chartered case, sorry, I've jumped ahead of myself. In the Standard Chartered case, Mr. Justice Green refused to strike out very similar claims. And he sheltered behind a case management decision. He said, well, trial's going to be needed anyway, and there'll be little cost to be saved by striking out. But really, I think he doesn't buy it. He thinks that this is a developing area of law, and he isn't sure that Mr. Justice Leach is necessarily correct, that the entirety of the law on deceit is imported. And he's particularly troubled by this omissions issue, and whether Mr. Justice Leach is, in fact, applying a different deceit or reliance test to omissions. And he wonders whether, once that shackle is removed of applying the deceit reliance test in the sphere of omissions, whether you can just have entirely different tests for reliance in this new creature of statute. I'll come on to explain how the claimants have argued that. So the first question that we need to deal with is Mr. Justice Leach correct to say that the law of deceit applies? Because Credit Suisse and Ivanishvili is a deceit case, and so it needs to apply deceit to the law of Section 90A for it to be really most relevant. And, for example, the claimants in Standard Chartered say that deceit reliance doesn't apply exactly. They say, well, look, it can't apply to omissions for the reasons I just said. You can't have reliance on a dishonest omission in the law of deceit. So it must be a different test in Section 90A. And if it's a different test, well, let's throw out that really annoying bit of reliance that says you test reliance by comparing what would have been done if no representation had been made. And they say, well, let's test it by comparing it to what the representee, what the claimant would have done if they'd known the truth. If they'd been told the truth, what would they have done? And that's great if you're a claimant, because as soon as you know what the truth is, oh, I never would have done that. You have the benefit of perfect 20/20 hindsight, and everyone's off to the races. There are quite a lot of cases, including at Court of Appeal level, that say that that's wrong. But maybe there's a way of squaring the circle and finding a way for deceit reliance to work, for the law of deceit to apply here. Because I think that an implied representation is not like an implied term. In contract law, an applied term is never spoken by anyone, but the law supplies it. We use the same word in representation. We say it's an implied representation, but it's not really. It's an express representation. It's just the words of the representation aren't spoken out loud or written on a piece of paper. But when you sit down in the restaurant, your clothes are speaking. Your paint is speaking as if you had written words on the wall. You are saying something. It is always an express representation. And the omission is a problem. But you can also, if you want to, characterize an omission that way, once you have a duty to speak. Once you're in a situation where the regulatory sphere, for example, Section 90A, says that you've got a duty to disclose, well, as soon as you have a dishonest silence in that sphere, you are saying something. You're saying, there's nothing else you need to know. There's nothing else that I'm obliged to disclose. You are saying something by your silence. So I think you can probably, if you want to do it that way, solve Mr. Justice Leach's omission wrinkle and argue that the law of deceit applies, and that's how it works. So I think it is at least plausible that the law of deceit does apply to the reliance test in a Section 90A claim. And I'm sorry, we're jumping back and forth. It's my fault for the organisation of the slides. But the Credit Suisse decision goes some way to helping a Category C claimant. Mr. Justice Leach had said in his decision that a representation needs to be actively present to the claimant's minds or to those directing their investment. And therefore, the claimants or their representatives have to have read the information in order to rely. But that's Cockerell's bridge of reliance theory, and that's gone. The Privy Council say that the board concludes that under the law of England and Wales, it is not a legal requirement of a claim for deceit that the claimant was aware of the representation or understood it to have been made. And there being no appellate authority on the point, the English courts, they're not obliged to as a matter of precedent, but they will follow it. That is the orthodoxy. So that's one plank gone. And relatedly, that was one of the planks of the defendant's defence in Standard Chartered. That was, I think, Adrian Beltrami's third point, that the claimants needs to have been consciously aware of the representation when they're relying. And so they just say, easy, just get rid of Category C. You need contemporaneous conscious awareness. They obviously don't have it because they haven't read it. Just get rid of it. It's a shortcut, which is what it's easy to. It's amazing that we can stand here and say, oh, well, it's obvious that all of these judges were wrong for the last 15 years, but everyone's thought they were right, or at least we've had to accept that they were right, I should say. And that has now gone, that shortcut has gone. And the key question is influence or causation. And so as a claimant lawyer in these cases, I think you will have to argue that the claimant has been influenced to hold a false belief or make a false assumption. And that one cause of that is the published information, albeit that the published information goes through the filter of an intermediate stage market price. And so I think you have to argue some version of that intermediate price being somehow similar to the situation in Brown and Innovator One or Ross River of that advisor who receives multiple pieces of information and spits out a recommendation to their client. And I think that is at least arguable that you can do it that way. And so you would argue in Credit Suisse terms that taken overall, the question is, does the representation influence the defendant's belief influence the claimant to hold a mistaken belief or assumption? And in these cases, it does. I think the difficulty are these. At the heart of the Credit Suisse decision, I think, is this idea that I've been referring to, whether the misrepresentation causes the false belief or the assumption. It's all about causation. Four parts. The representor intends the representee to be influenced by the representation, and by his words or conduct, the representor in fact induces the representee to hold the mistaken belief, and the representee acts to their detriment because of that. But there's wording in here which is a problem for the claimants in a Category C case. That at the beginning, that reliance or inducement is an essential element, and the representation must have deceived the claimant. Reliance requires the representation to operate on the mind of the claimant, albeit it can be subconscious. And at the bottom, the assumption was one which the claimant would naturally be expected to make in response to the defendant's words or actions. And that is the main problem for the Category C claimants here, that when you take a step back and say, well, what is the false belief or mistaken belief or assumption that the claimant holds? Well, in the restaurant example, remember, it's the claimant intends to pay. In the shares example, it's probably some version of three things. The shares are priced at X, that's my belief. Probably the market thinks the shares are worth X, and there's not some undisclosed or misstated matter which undermines both of those things. So if it's all about causation, what causes that belief or assumption? Well, in scenario C, the company will argue that the claimant's assumption or belief doesn't arise at all in response to the published information. Remember, those are the words of the statute. That the claimant's really responding, they will say, entirely to the subsequent price representation made by the market. That the claimant is looking at the price. They're saying the price today is this, and that's what I'm relying on. And by analogy, the claimant's not being directly influenced by the defendant's representation. They haven't visited the house, they haven't seen the whitewasher, nor has their representative. Instead, the claimant is being influenced most directly by a complex representation. The price is this, which is a representation made by the market, a great many third parties, and which has lots of sources of information feeding into it. True it is that one of those sources is the misleading company information, but the price is, and there'll be expert evidence in these cases about it, but I think it will be strongly argued that price is a sort of Chinese whispers made up of lots of different sources. And so you will argue, as a defendant lawyer, the claimant has just not been influenced by the representation, by the price information. What you've been influenced by is other people's collective opinion that the company is worth X. And there are some rays of light. We set against that. You say, well, we know that you only have to be influenced by one, that a fraudulent misrep only needs to be one source of your causal reliance. It doesn't have to be the source. But again, the companies will point to the paragraph 165 of the Credit Suisse decision, where it says, generally, no claim can arise if the claimant was not even aware of the conduct itself, particularly where it takes the form of words. I would expect to see that waved around quite a lot over the next few years, because that's exactly the situation that we're in. It is unless it's an omission, you've got a misleading statement which takes the form of words, and generally, no claim can arise from that. And claimants will have to respond to that by saying, well, yes, that's true, but there are, of course, exceptions to that rule, like the dry rot, where the claimant is not even aware of the conduct itself. I think, finally, the companies will argue that the market price is not quite the same as the representative being influenced and making a recommendation. When those pieces of information come in, the representative distills them and makes a representation. That's different in a few important respects to the price. In those situations, some of the reliance is really happening via the middleman themselves. That they're the real decision maker, and they're providing a recommendation that dictates the decision of their clients. That's really what happens in Ross River, where it's the football club's advisor, Mr. Lee. It's his reliance that's the key. It's what Mr. Justice Briggs, if he then was, says. And that stuff just isn't present in the price example, because the market price isn't an agent of the claimant, and the price isn't a decision that's being taken by an agent or an agent-like figure. It's not even a recommendation, so it's different. I think if you're a claimant, you probably have to argue back by coming back to causation, and you'll be pleased to hear that this is pretty much getting to the end. That all that matters is causation, and whether the deceitful arrow ultimately hits the target. What matters is that the representation influences the representee. And in the advisor example, you've got multiple pieces of information feeding into a recommendation. He makes a single recommendation. So one of the causes of the claimant contracting is the deceit. It's only one of those things that fed in to the recommendation. And it's just like that in the price scenario. Multiple pieces of information feeding into a price, one of which is deceitful. That price, the price comes out as a single item, which causes the claimant to contract. And one cause of that was the piece of deceitful information. The problem's going to be proving it, that it's going to be really hard to prove that the representation is still a cause, and that once it flows into the price, it doesn't just become untraceable like a fund of cash. But as Mr. Justice Green says in Standard Chartered, this is an evidential question for trial. You can imagine a scenario where everyone in the market is looking out for a single update in a company's information, and it really is that one piece of information or omission which moves the market on a given day. And that it is only that price movement which causes a tracker fund to act, to invest, or to be alarmed enough to disinvest, such that you could well find a scenario where there is an unbroken chain between the representation being made in the company's information and the price and the investor relying. And that's going to be a question of fact, which you can only determine at trial. And so the key question, and the one asked in so much of his excellent book by my old tutor, John Cartwright, should be, is there a causal link between the representor's statement and the representee's decision to act in such a way as to cause the loss he claims? And if you replaced the words "in reliance on" in this paragraph, not that paragraph, in this paragraph, if you replace the words "in reliance on" published information, which so strongly points you in favour of somebody needing to look at the published information itself. But if you said, well, all that "in reliance on" means, with the common law deceit test, where at least one of the causes of the claimant's action was, well, suddenly starts to look a lot better if all you have to do is find that one of the causes of the claimant's action was the published information. Causation ultimately is quintessentially a question of fact. And so the scope for factual argument about all of these things, these claims should now go to trial, but it'll be an uphill battle. And so the three takeaways from tonight are, first, proving reliance, particularly in an implied misrep case, just got a lot easier, which is good news for group misrep claims. Two, in a Section 98 FSMA claim, Credit Suisse is definitely a step in the right direction for the Category C claimants, and should help claimants more and more avoid strikeout and make this all a fact-sensitive question which needs to go to trial and which will inevitably prompt more of these cases to be settled. And finally, one thing's for sure. If you thought that group misrep actions were dead after the last 15 years, you'd have been making a big mistake. Big, huge. Thank you very much for listening.